Welcome to Law Made Simple. Today, we're decoding medical negligence in India. It's not just a medical error, it's a legal breach of duty. Negligence happens when a doctor fails to act with reasonable care. This includes misdiagnosis, delayed treatment, or surgical mistakes. Even failing to inform the patient about risks can be negligent. The harm must be proven, not just suspected. Medical negligence can lead to both civil and criminal liability. Patients can seek compensation or file criminal complaints. We'll explain how to file a case and what proof is needed. We'll also cover what to do if relatives are kept out and something goes wrong. Real examples and preventive tips are coming up. Let's empower patients with legal awareness. Because your health rights matter. Let's begin. Medical negligence is governed by multiple laws in India. Section 304A of the Indian Penal Code, 1860 deals with death caused by negligence. The Consumer Protection Act, 2019 allows patients to file for deficiency in service. Hospitals and clinics are considered service providers under this law. The Indian Medical Council Regulations, 2002 set ethical standards for doctors. Violations can lead to disciplinary action by medical councils. Civil suits under the law of torts allow compensation for breach of duty. The Limitation Act, 1963 sets time limits, usually 2 years under CPA. The Indian Evidence Act, 1872 governs what proof is admissible in court. And Article 21 of the Constitution protects your right to life and dignity. Together, these laws form the backbone of patient protection. Knowing them helps you choose the right legal path. We'll now walk through how to file a case step by step. Stay with us. This is Law Made Simple. Filing a medical negligence case starts with documentation. Collect all medical records, prescriptions, bills, and discharge summaries. Decide whether to file in consumer court or civil court. Consumer court is faster and cost-effective for compensation. Draft a complaint that clearly states the breach of duty and resulting harm. Include dates, names, and specific incidents. Attach all supporting documents and medical bills. Get an expert medical opinion from another doctor. This helps prove that the treatment was below standard. File within the limitation period, 2 years under the Consumer Protection Act, 2019. You can also file a complaint with the State Medical Council. They may initiate disciplinary action against the doctor. Legal advice helps you choose the best route. Let's now talk about what proof is needed to win your case. Stay tuned. Proof is everything in a medical negligence case. Start with medical records, prescriptions, test results, and discharge summaries. Photographs of injuries or hospital conditions can be powerful. CCTV footage or audio recordings help show what happened. Call logs and WhatsApp chats with hospital staff are admissible. They help establish communication gaps or refusal of care. Get an expert medical opinion from another doctor. They can testify that the treatment was below standard. Maintain a timeline of events with dates and details. Witness statements from staff or other patients can strengthen your case. Even small details can be crucial. Preserve everything digitally and physically. This builds a strong case. Let's now address a sensitive issue, when relatives are kept out. Coming up next. What happens when relatives are not allowed inside the hospital? This is common in ICUs or during emergencies, but it raises legal concerns. Patients have a right to informed consent under the Indian Medical Council Regulations, 2002. Doctors must explain procedures and risks to the patient or their legal guardian. Hospitals must disclose treatment details to family members, especially in critical cases. Relatives can demand written updates or daily summaries. If denied, preserve proof, email requests, SMS replies, or written complaints. Take photos of notice boards or entry restrictions. Record verbal refusals if legally permitted in your state. These records help establish lack of transparency. Refer to Chapter 2.1 and 7.22 of the Medical Council Regulations. They mandate ethical communication and patient rights. If something goes wrong, this proof becomes crucial. Let's now look at real examples of how patients preserved evidence. Let's look at how real patients preserved proof of medical negligence. One patient took photos of an infected surgical site, used in court. Another recorded a nurse refusing to call the doctor, key evidence. A family emailed the hospital daily asking for updates. The lack of reply helped prove negligence and concealment. A second doctor reviewed the case and gave a written opinion. This showed the first doctor's error in diagnosis. Bills and prescriptions show what was paid for and what was done. Maintain a diary of events with names, dates, and incidents. Even small details can be crucial in court. Witness statements from other patients or staff can support your claim. Preserve everything digitally and physically. Use cloud storage or email backups to avoid data loss. This builds a strong, organized case. Let's wrap up with your rights and final tips. Every patient has the right to safe and ethical treatment. This includes the right to be informed and to give consent. Doctors must explain procedures, risks, and alternatives. You have the right to file complaints and seek compensation. Use the Consumer Protection Act, 2019 or approach civil courts. Keep all records, medical, financial, and communication. Act early, don't wait until it's too late. The Limitation Act, 1963 sets deadlines for filing claims. Educate your family about these rights. They may need to act on your behalf. Medical negligence is serious, but you're not powerless. Stay informed, stay organized, and stay proactive. Law Made Simple is here to help you understand and act. Like, share, and subscribe to Law Made Simple. Let's make legal literacy a public movement. Stay safe, stay aware.